Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our community conference call. We do this every other Thursday. We try to answer your questions, and of course, this does not establish an attorney-client relationship. You would have heard our disclaimers when you logged in and heard the recording in the conference call. I'm going to start with the posted questions. I didn't see anything that I could call a frequently asked question, but I haven't had the time to review everything in detail, so I might take a little bit extra time reviewing your questions. Jersey Garden, I'm an H-1B employed but was let go on 2nd July. I entered USA in July 2009. Green card processing resulted I-140 approval in March 2016, priority date 2015. What are my choices to stay? Well, don't ignore also you have that 60-day grace period. The way the H-1B 60-day grace period works is that if your employment is terminated, now the regulations are not real clear about whether you have to be fired or you have to quit. In either case, one second. So if your employment is terminated for whatever reason, and I have actually looked into this issue, what if your H-1B is denied? Do you still have that 60-day grace period? And I think you do. Okay. That 60-day grace period only works if you have time remaining on your I-94. If you are at the end of your I-94, you may only have a 10-day grace period. Double check with your lawyers. There are some complications there also. But the one that I wanted for you to know, because I had a consultation yesterday, and it appears that a lot of people are still not aware of the extraordinary circumstances EAD or a compelling circumstances EAD. That might be another thing to consider. It doesn't apply in all cases, but the law also says that as long as the compelling circumstances EAD is pending, you're not running unlawful presence if you applied within the life of your H-1B or the grace period that followed. So he says, Jersey Garden says that, what are my choices to stay in the US, giving the happy path scenario and the alternate options? Spouse is on F1 OPT, good till Jan 2020, and should have H-1B effective October 1st, 2019. Current I-94 date is October 16th, 2020. Now, I guess that's yours, I hope, or is it your spouse's? I have entered USA in July, I-140 approval priority. So I don't know when your I-94 is expiring. I hope you're on the phone. You can tell me. Why don't you press *5 if you're on the phone? Press *5. Okay, good. You are here. Let's take this question. This is from Minnesota. Okay. Let's see. Oh, you put your hand down. I guess it wasn't your... Oh, up again. All right. Yeah, when does your I-94 expire?
So it's 10/16/2020.
Oh, good. Okay. So you do have a 60-day grace period.
Yes.
Okay. So question is, need to get a new employer within 60 days. Do I need to get EAC number? No. You just have to have your H-1B filed with the USCIS within that time. Remember, it takes about a week to get the LCA, unless the employer already has an LCA. So functionally speaking, you have about a 45-50-day grace period. Once you file the papers, you can join the new employer and start working. Okay?
Okay.
If I have EAC number but joining date is in September or October, is it fine to have no job until then? There can be no temporary jobs, of course, and I'm not sure what you mean by that. What do you mean when you say joining date is in September or October? Because see, once you file your H1, you are good to start working if you like or not working if you like. You can only start, you can only know for sure once the case is approved, whether it has been approved. And the way they approve H-1Bs is always going forward. So if you file your application in August and it gets approved in October, they will authorize you employment beginning October. But that doesn't mean the work that you did between October and August, while your application was pending for the same employer, is illegal. It's perfectly okay to do that. So you can join the employer upon filing if the filing is done within 60 days. Okay?
Okay.
Now remember, you don't have to have the ESC number. The way I read the law, and I don't think I'm being too aggressive about this, the way I read the law, what we need is the physical receipt of the papers by the government. So once they have received the papers, I think you can start working. If the RFE transfer or response gets rejected, I guess you would have to, well, you still have time period. Now here's the interesting thing. If another employer applies for you, I think your lawyer should very carefully look at, you will have another 60-day grace period. How does that work? Because that 60-day grace period actually belongs to each incident of the application. What if the same employer files again? Do you have another 60 days? Don't know for sure. I'll have to look at the law. But that 60-day period is not a one-time deal. It can be used time and again. Okay?
Okay.
I do not like the F2 status simply because it's so easy to deny F2. I prefer H4. That's so much better. Since 60th day is August 30th, question is for 1 month of September for maintaining status. Can I move to H4 from 1st October? Yes, absolutely, and that is a much better status. You can always file a bridge F2, and while the F2 is still pending, apply for H4 simultaneously. F2 will cover you for the period of September, and H4 will begin from October 1st onwards. That should be okay. Or you can just step outside USA, get H4 visa stamp, and come back. Okay? So if your change of status is pending and you apply for an H1, but the change of status is not approved on the date your application is up for decision, government can approve the H1 but make you go outside USA. So unless the H4 is approved on the date they decide your case, they can make you go outside USA. All right? Are you okay, sir?
Yeah, I'm
okay.
good.
Well, good luck.
Yeah, thanks.
All right, let's take the next one. Swati. She's here on L1B past 6 months. Husband got L2. Applied for EAD. Application was approved. He traveled back to India. Last month, USCIS dispatched EAD, but USPS could not deliver that. She called them, e-request, no response. How should I proceed now? There are only two possibilities once you have tried everything at the USCIS offices. One thing you can do is open an ombudsman's request, or you can contact your local congressman's office. Those are the only two things that I know of. Okay. *5 if you have a follow-up question on this. *5. Press *5 on your phone. Okay. Let's go on to the next one. Van is 23-year-old high school unmarried male living in India, Punjab, Bathinda. He's got ownership in a C Corp with partners from USA and Canada. 6 employees, generate about $1 million. I take $25,000 per month wired from Chase to my Indian bank account. I want to move to the US, get a green card. What is the best course of action? Well, if you have the money, you can apply for EB-5. You can, of course, borrow the money as well, as long as it is from legal funds. The problem is, beginning November 21st, the investment amounts for underserved, backward area, etc., are going up from 500,000 to 900, and if I remember correctly, from 1 million to 1.8 million, something like that. So they are increasing the amounts of investment. I don't see what else you can do right now, Van. That's the only thing that I can think of. Investment visa option. There is the L1A, EB1C option, but smaller companies are having trouble getting L1A, EBC approved. We are still getting them approved, but they're a lot more difficult than they used to be. You should look a little bit into it, read up on it, L1A, EB1C, which is a category that's quite quick. You can look into those as well. The idea there is that company is transferring one of their employees from location X to location Y in another country, and the location Y has a sister company, etc. So look into that, and if you have any follow-up questions, you can come here or you can set up a consultation with us. *5 if you have a follow-up question, guys. *5. Okay, let's go on to the next question. Carla says, I'm on H1B, spouse is on H4, doesn't have any ED. We want her to go back to India, launch a startup there. She'll be the shareholder and director while she's there. They'll provide services only in India, no US customers. The law in India does not mandate the director to be paid a salary or shareholder to withdraw profits. It's the same in USA, most places that I know. She could form the startup, stabilize it, then come back to US. Can she now continue to run the startup in India while in USA? So we've had a lot of discussion about this. I don't have any particular opinion on this, but I can tell you what the majority opinion of the immigration bar is. At least majority of the people that I have heard talk about it. Lawyers seem to think that if you are on the US soil conducting a business which is in a different country with absolutely zero connection with the United States, you should be okay. I have no comments about this. I haven't given it a lot of thought, but that's what a lot of my colleagues believe. Will she have to declare anything? I don't see why, because if she's not working, personally, I would still disclose it in a letter when I do my 485 or any other kind of change of status where this might be relevant. I would disclose it, but I would tell the government that this company has, or this nonprofit that I'm running, or this foreign company that I'm running has no connection with the United States. I tend to err on the side of too much disclosure. I don't like to keep things from the government. *5 if you have a follow-up question. *5. Okay. Let's go on to the next one. Praveenji, your timeline is a little too long. I usually don't have time to review all that. I wish you would just summarize the question for me. Don't know what's going on. H1 visa, H1 extension visa stamping. You are in 221G. Okay. Revocation. Notice that my employer provide documentation. Reaffirmed. Take fresh appointment. I was asked to submit. I'm not sure who has just raised their hand. I'm still reading up on this. Car embassy appointment. My employer submitted, waiting for response. Okay, 797 expired. Well, you have to apply for an extension. Don't wait for a decision from the embassy. It'll be nice if you get your I-797 extended, and I'm not sure what the local protocol is, and maybe they can give you an updated, they can accommodate that updated 797 or extended 797 in the same interview that you are going to. Okay, that visa interview is useless without an extended 797. They cannot really do anything for you. Okay, I have a hand up here from California. Let's see what we have here. California, go ahead, please.
Hi, Rajiv. I had a question about a follow-up about the previous question. So my name is Rajesh, and we are in a similar situation. Like my wife and I both are on H1B, and we're developing a software product which we want to set up a startup in India.
Uh-huh.
But the customers will be worldwide, including US.
Uh-huh.
So is that something that we can manage it from here while we are on H1?
I am reluctant to say that's okay because if there is a connection with the United States, that might be objectionable to the government. I don't have any specific law on the immigration side to point out to, neither for you nor against you. What is the worst case scenario? Okay, let's say you do this business. As long as you disclose this in every application you file, wherever there's a relevant question. For example, if the questions asks you have you ever worked without authorization, you say yes, and then you explain that the work that we did was not for any US company. Okay. Now, if the government accepts that, what can they do? The most they can do is make you go outside for visa stamping for your status, which is not the end of the world. Okay. And if it comes up at the 485 stage, all you should do is step outside USA before filing 485, come back in, and then stop doing the work and file the 485. Then the section 245K protects you. Okay?
Okay, because it reflects the status. Okay.
Yeah, so the worst case scenario, I hate to stifle people's entrepreneurial spirit. So that's why I'm telling you what the downside is. As long as you don't lie about it, you don't try to hide it, I don't see how it's going to hurt you tremendously. Okay?
Okay.
Good luck, sir. You're welcome. Okay, let's go on to the next question. So, yeah, you have to extend your 797, and whether that can be accommodated in the same interview that you've already scheduled, I'm not sure. I don't know what the local protocol is, not off the top of my head. I'll have to have somebody look into it. So have your lawyers check that, okay? Next question is about the 526 from Gunjan Manthe. The USCIS, for you also, they sent back to the USCIS reaffirmed. They forwarded your petition to NVC. They have not received the petition. How many days does it take for the NVC? My own, I can't give you an exact number, but my own experience with most of these inter and intra-agency movements is that it's about 10-day process. Will NVC notify me? They should, but you should also follow up with them. Is there any way to track my petition? Not really, but you can open a service request with the USCIS. Maybe you can figure out what date did they send it out and what you should do if NVC says they have not received it. Does USCIS have a process whereby it can be sent again? Okay. *5 if you have a follow-up question on this. *5. All right. Let's see. This question is coming out of India. All right. India, go ahead, please. Yes, India.
Hello, sir.
I can hear you. Yeah, go ahead.
Rajiv Mathur, son of Vijayan Rajiv, for the previous question of I-526 petition.
Okay.
So it has been around 2 months since
that's
the
too
USC
long. That's too long.
It.
Yeah, I think that's too long, Gajanan. I think it's maybe you should try to follow up with the NVC.
So, we should mail or we should generate a service request at USCIS.
Do both. Why should you do one only? You can do both. All right.
And okay. And can we include congressmen in this too?
Why not? Why not? You can do that as well. I don't see why not. Okay. Good luck, sir.
Yeah, okay, thank you.
Bye-bye. All right, guys, gotta hurry along. If you have any questions, I'll be happy to answer them, but I can't hold for dead air. Uh, Rahul says, I received my EB3 green card recently. I'm considering a new position. My job is bona fide. You've been there for 3 years, the company through whom you got your green card during the EB3 process. My salary was slightly below the amount in perm, but they adjusted it about a month. So that's pretty good. I changed my mind after getting my green card as another company reached out with a much better offer. Is it okay to change a job about a month after getting a green card? In my view, it is. That's the way I see it. I don't see any reason why it should be a problem. And thanks for pointing out that there's a dead link to the frequently asked question where I have addressed this issue. I've already sent it to our team to look at the dead link. But personally, this is my opinion. I cannot tell you that the government will agree with me. But in my view, on the date when you got the green card, if you had no intention to move, but a month later you got a much better offer, I would be surprised if we took this case to court if the government came after you and lost it. I think we would win a case like that. There's no law that says you have to stay there forever. Okay. Star 5 if you have a follow-up question on this. Star 5. Next question, India, Canada. Received my green card last year. My family was in Canada. So Rajiv, recommended AOS, consular processing for my family, which we did. We went to the interview in Montreal. I got a 220G because they didn't have an I-134. That's a minor thing. No, I see. That's the problem. Your dates are retrogressing. Will my case be still processed? Will they wait till the date becomes current? So difficult to say. So difficult to say. What happens is if the case is not processed in the month the dates were current, there's a high likelihood they'll just hold the case until the dates become current again. Sometimes if they have already processed the case, they can request a visa number and that means you're going to be fine, but otherwise you're going to have to wait. So it's difficult for me to say. You can try reaching out to the consulate and see if they had already received a visa number for your family's case. I don't even know if they need a separate visa number or just the primary needs it. Double check it with the consulate. I don't know if they'll respond, but doesn't hurt to check. You can email them. Star 5 if you have a follow-up question. Star 5. Jay Vijay says, I got employment-based green card. This is about AR11. I got employment-based green card last week. Wife and kid got their green cards last week. H1B, H4, okay. I-485 was filed November 5th, 2018. I moved to a different address on November 20th. And after the move, I filed AR11. My wife and kid did not move, so they did not file AR11. I'm getting confused between AR11 and I-865. No, I-865 has no relevance to you. AR11 is what matters. Only file AR11. I-865 you will file only if you filed an I-864 affidavit of support for your family. You shouldn't have. You probably filed an I-134. I-864 can only be filed by US green card holders or US citizens. Since until the approval of your change of adjustment of status, you are still a non-immigrant, not a green card holder, you should not be allowed to file 864. There was a time period in which the government was insisting people file it, but then realizing that was not really even appropriate, they backed off. Long story short, unless you have filed I-864, you do not need to file I-865. If you have filed I-864, file I-864 for yourself and AR11 for your family. Once again, AR11 for your family for sure, no doubt about that. I-865 only if you filed I-864 affidavit of support, not if you filed I-134 affidavit of support. Star 5 if you have a follow-up question on this. Star 5. Okay, let's take the next question. Parents are 75. I'm a US citizen. Green card is expiring in 2022. Oh, but they've lost their green card. I think reapplying is the cleanest thing to do. The only problem is if you get them here on a tourist visa after surrendering their green card, and they do get the tourist visa, the problem is if you enter on tourist visa with a preconceived intention, already a plan to apply for a green card, government sometimes goes after people saying that that's fraud in both procuring the visa and in using the visa to enter the United States, because their intention was not tourism, their intention was to get a green card. Now, change the scenario. They have no plan to apply for a green card. They just come on a tourist visa, but 4 or 5 months later, you convince them to apply for a green card. That's fine. So you can change your mind once you get into USA after 3 or 4 months, but you cannot have a preconceived idea, a plan to apply for a green card. Okay, that certainly is very quick, but getting a tourist visa stamp after you had a green card itself is questionable. Doesn't hurt to try, because you can always fall back upon applying for them through consular processing for green card anyway. And you're right, it takes a little bit over a year, but that's always the backdrop option. I hope this makes things a little clearer. *5 if you have a follow-up question. *5 if you have a follow-up question. Okay. Prasad Gupta says my I-485 interview is completed in July. My priority date is not current. Case is sent to NBC. I'll take the final decision when the date becomes current. If you change jobs, you should be filing Supplement J. Yes, sir. Okay. In my view, Supplement J should be filed. I don't think it's required by law, but I think it's a smart thing to do. It will also help your naturalization application 5 years down the line. *5 if you have a follow-up question. *5. Okay. You've got your H1, but the change of status from F1 to H1 was denied because you took more than 12 months of CPT at the same master's level. If I go to Canada, Mumbai consulate was indicated in the H1B petition. Can I go to Canada? In my view, absolutely. You can go to any country as long as they will take you. I have not heard of, there was a time when Mexico was not taking third country nationals for a short period, but I've never heard of a third country national not being allowed to apply in any country they happen to be in. So in my view, yes, you can. Do I recommend any specific consulate? Not really. I think Ottawa, if they are still doing NIVs, I don't remember off the top of my head, used to be preferred because it's a small town, easier approach. But I don't think it's really specific to one consulate. A lot depends upon the individual who interviews you. Can they ask you questions related to CPT or denied status? Absolutely, they can. But there's no harm. You haven't done anything. In my view, those denials are quite questionable. Somewhere along the line, I think there should be a class action lawsuit filed against the government because their interpretation of the CPT regulations is illegal. They can't change the rules after we have already played the game. Visa officer asked me about, have you used more than 12 months? You answer, hey, I wasn't violating status. In fact, your lawyers can explain that to you. I personally don't see any problem, Mangaleshji. You can, just because you use CPT doesn't mean you should not get a visa stamping. *5, you have a follow-up question? *5. Okay. Next is, there's a date of birth difference in mother's birth certificate. 75-year-old information. 20 days off. I use the, see, if the birth was, I think, before 1970s, you don't get birth certificates. Resubmit the I-485 on I-130. I think it'll be a good idea No, I think this is a little bit more complicated than I can help in this call, but this should be straightened out. Um, I don't know if I would refile the I-485 I-130. I would check with the USCIS customer service and see if I can just send in a corrected I-130 I-485. Okay. So father's surname was used instead of, because hers was blank. So I want that to revert to blank. I think you need to amend, and you can again call in to the USCIS customer service, ask them that you want to make certain corrections in the forms. How do you go about doing it? And normally they should tell you that you can do that by just resending original signed forms, and that should take care of it. But you should have a consultation with a lawyer and see if the documentation that you're submitting for the birth and the discrepancy in the birth is going to be sufficient. That's my main concern. *5 if you have a follow-up question. *5. Okay. This one is from our neighborhood, I guess, Virginia. All right. Go ahead, please. I can hear you. Go ahead.
Yes, sir. Thank you for the recommendation on the amendment
Yes, sir.
of the form.
Yes, sir.
The birth certificate we did get was kind of the original one from the municipality. And so I think that's what we use. But like in all the additional information for the forms, I've been honest and declared that passport has different, birth certificate has different.
Good.
So I think that,
Yeah, I'm not concerned about
I think
it.
I attached that.
I don't think this is going to be a fatal issue. It's just a question of explaining things appropriately, and use the real date of birth, whatever that is. Okay.
Right, and we use the real date of birth, sir, and I think the issue with the passport getting updated is the U.S. Embassy said they won't do it because there's no secondary verification of that information,
That's okay.
even though we showed them the birth certificate.
That's okay, because remember, you need a passport only to enter India. So when she goes back, she can apply for a change in her date of birth. Okay.
Okay.
Anything else?
No, I think we will speak to you on Monday. We'll come in to see you.
Oh, okay. Good luck, sir. Bye-bye.
Okay. Thank you.
Kailash says, completed master's degree, H-1B approved with employer A. It will be activated this October. I haven't done my H-1B visa stamping. Kailash, I hope you are on the phone. I want to know whether you received your change of status. Because if you received your change of status, that's good. So the question is, can I get my H-1B stamped before I do H-1? Yeah, do I need to get my H-1B stamped? That depends if you received a change of status. So if you received a change of status, then you do not need to get it stamped. But if you did not, you need to get it stamped if you want to do an H-1B transfer. The problem is, government has not been very clear about transfers before October 1st. The last time I spoke with somebody in the government with respect to this situation, I was told that as long as the old employer who got your H-1 approval for you does not revoke the H-1 before October 1st, doing a transfer should be okay. All right. *5 if you have a follow-up question. *5. Okay. Last question for today is, Madhu says, I'm working as a consultant. H-1B, I-140 is approved. Company is going to be closed, or they will rename. Renaming the company is no problem. But if it gets closed, now, if your I-140 has been approved for more than 180 days, you should be okay for both your priority date as well as for your ability to extend your H1 beyond 6 years with any employer. But if your I-140 has been approved less than 180 days, then you could have some issues. Okay. *5 if you have a follow-up question. *5. Okay. Guys, oh yeah, there is a follow-up question. This is from, I guess, New Jersey. Yes. All right. Yeah, New Jersey, go ahead, please.
Thanks for explanation. Actually, not only the company is going to be closed because of some other court case also. One of the employee is going to sue to CEO because he came as a business visa and acting as a CEO and finally one of the salesperson. He's a US citizen. So he's going to put the case in Department of Labor and the DOL and USCIS because one are closed.
Sorry, your
Also,
voice is breaking up. Let me tell you this. I understood that the CEO of the company may not have been authorized to work in the US. The question is, how illegal was the entire green card transaction? I can't give you an opinion without knowing all the details. But if government finds that, for example, the papers were signed by somebody who was not authorized to work in the US, or there were some other irregularities, they can go back and revoke your green card, your I-140. If they revoke your I-140, then you get to keep nothing. You don't get to keep your priority date, and you don't get to keep the right to extend H1.
Okay. So actually, the CEO not signed directly. The CEO appointed some HR. The HR signed on my document.
Well, I don't know. I can't predict how that's going to play out. But I think it makes a difference if the signatory was not authorized. Can the government still go after reopening and revoking the I-140? They can, but I think they have a weaker case if the person, this is just my first guess, they have a weaker case if the person signing the forms was a US citizen or US worker. I think that will be a more difficult case to revoke the I-140. Okay?
Okay.
Good luck, sir. Good luck. Guys, I have a call scheduled in about 20 minutes at 1:30. I can try to answer a couple of questions quickly, but I have to... Okay, somebody raised their hand before I could say anything. Okay, I have 2 questions. I can answer these 2 questions, but please no more. Maybe next time, okay? So let's begin first with... where is this call from? Washington State. Okay. Washington State, go ahead, please.
Hello. So my name is Madhu.
Yes.
I have a very quick question for you. So basically, I have my I-140 approved from my previous employer B, and during that time, the SSC code that was used was equal DBA and all that stuff. So everything was said and done. And now I changed to employer C, and now they are trying to file for this I-140. And the job profile is not really a match. So I've been working as a developer now for last 3.5 years. So since the job profile varies, it's in the same major code, and this employer is asking me to get the letter from the original, the employer A, and ask them to change all the technologies and stuff like that. Should I be doing that?
Never ever make up things, ever. No, that's fraud. Okay?
Okay, so can I ask them to continue the file of the similar or same SOC code that I was approved earlier with the employer B?
See, I don't think I can answer these questions without looking at the case. Okay? If you have reasonably competent lawyers, you don't need to worry about it. They should review all these things for you. But if you want me to review, I need about an hour to go over your paperwork. Okay?
Okay, thank you.
Yeah, I can't really comment. But overall, first of all, there is no law that says that you got to be stuck in the same field. If you are redoing your green card, it can be in a totally different field. So I'll give you an example. Let's say you have 2 degrees. You have a degree in information systems and you have a degree in chemical engineering. But you've worked all your life as a software developer. But recently you found your love for chemical engineering. Can you file an H1 through chemical engineering? Sure, you qualify. Can your I-140 priority date that was approved as an IT guy be used for a green card through chemical engineering? Absolutely, no problem at all. Okay?
Okay, thank you.
Good luck. And the last question today I have is from Virginia. Virginia, go ahead, please. We can hear you.
Yeah. So this is just going back to the question about the mother's date of birth being different
Sure.
in the forms
Sure.
that get filed versus the passport.
Mhm.
So if you recommend that I call them and try to revert back to the date in passport, I think the question is that would they say it's a fraud because birth certificate
No,
is something?
I am not concerned.
okay.
I'm not concerned about fraud allegations. I'll tell you why. 2 things go in your favor. One, you are yourself trying to correct the situation. It's not like you got caught in a lie. That's a good thing. But even more importantly, date of birth is not a material matter in my view. You can only be held up to fraud and stuff if you did something which is material to the application. Material to the application is that fact which, if it is disclosed, can either lead to facts that could be problematic or relevant, or could lead to a denial. Now, whether she's born on January 1st or January 31st, how does it matter? It's not material. Okay?
I see, yeah. And so obviously I would recommend to change it back to the original one.
I want you
I think
to.
we are worried about if the case.
I don't care about anything else except using the correct date of birth, whatever that is. Everything else
So
is.
the problem is correct date
everything.
of birth
Listen to me. Everything else is just discomfort and delay. Okay. Once you have corrected it, then you have to correct other things. That is discomfort. That takes delays. But that's how it should be done. Okay.
Right.
All right.
And then obviously for her travel.
I have to.
Go ahead.
I have to go. For travel and all, that's a separate issue. If I were you, I would be calling Customs and Border Protection. They actually answer your phone calls. So if you call cbp.gov, get their customer service number, make a note of what they say, that we have this discrepancy. If you carry all your documents, you should be okay, including your attempts at correcting this. Okay?
Mm-hmm. Okay.
Good luck, sir.
Okay.
All right.
Thank you.
Bye, everyone. Thank you so much for coming by, and I'll see you again in 2 weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.